Good morning. Today we are here to talk about the Texas Residential Real Estate Listing Agreement exclusive right to sell. So the first thing we're going to review is the compensation agreement between brokers. Now, this is something that has resulted from the NAR changes. Not only is MLS compensation, I'm sorry, broker compensation not ever going to be displayed on MLS. That's one of the biggest new rules. But if the seller or the selling broker is going to offer the buyer's agent any type of compensation, um, a compensation agreement form will need to be used. And so that's what this is here. If you are a listing agent, you can go ahead and fill this out with your client ahead of time and have it available to any buyer that submits an offer just so it's ready to go. Totally up to you. You can also wait and see what the buyer's agent gives to you because they should have one of these filled out as well. So I just wanted to go over that here with you so you're aware that you can fill it out ahead of time. The first section is the parties. So you would write the name of the listing broker and their information. Dalton Wade Inc. In the second section, you'd write the cooperating broker's name and information, and you would leave it blank if you were doing this ahead of time. Number two is the property. So you're going to write the full property address. Number three is registration. You're going to write the name of the cooperating broker's client in the blank section. Number four is the term. You'll write the beginning and end dates of the agreement. And number five is the cooperating broker's fee. So the listing broker will be paying the cooperating broker either a percent of the sales price or a set dollar amount. You'll enter the desired fee in one of the blanks. If a different option is chosen, you'll write that into the third blank. Family members and assignees of the client are bound to the contract. Number six is the entire agreement. So the agreement can only be changed in writing, and this agreement supersedes any previous agreements between the parties. And then at the bottom, you will have the broker sign and print, and the agent name will go at the bottom as well. All right, now we are into the first page of the listing contract. So the first section is the parties. You're going to place the legal name of the person or persons who are on title and the address that they currently live at, which might be different from this property. In a situation where an owner has given power of attorney to someone else, you'll write John Smith, power of attorney for Susan Smith. If a property is owned by a trust, you would put the name of the trustee. And in the last two blanks, you'll add their email address and phone number. Then you'll be writing in the brokerage information, and please make sure that it's all correct. So Dalton Wade Inc. We have the address written here, and then you're going to add your email and your phone number. The last clause of this section states that the seller agrees to appoint the broker and their exclusive real estate agent, meaning they have the exclusive right to sell the property. An exclusive right to sell listing agreement is a contract between a listing agent and a home or property owner. An exclusive right to sell specifies that the listing agent is the only agent you've hired, and the agent is guaranteed to receive the commission when your house sells. The National Association of Realtors advises that once you sign an exclusive right to sell agreement, the listing agent is entitled to compensation when the home sells, whether the agent um, finds a home or not. Number two is the property. Here you'll write the lot number, the block number, city and county, and the address and zip code. This information can often be found in MLS, but you can also find real property records, including the deed, the survey, the lien, the tax record, by contacting the county clerk site or the county clerk office where the property is located. B is the improvements. So this paragraph explains that all improvements, permanent fixtures, attachments, and property improvements will automatically be included in the sale. Oops. All right, looks like my screen stopped sharing. Okay. So a note here is that a fixture is an item that was once personal property, like a microwave, built-in espresso bar, or outdoor barbecue that has been attached in a way that makes it real property. And so that would make it a fixture. So just something to be aware of and to look out for when you are previewing the property. Accessories. So this paragraph will list all the non-permanent attachments that are included in the sale, like shutters, blinds, curtains, etc. This also includes the controls and electronic devices used to operate any items with software. D will be the exclusions. So if there are any items from the accessories and improvements list that the seller wants to keep, those should be listed here. If there are no exclusions, you'll write none in the blank. If a seller wants to retain any real property items, such as a fixture, the item must be excluded. Otherwise, it will be conveyed to the buyer as part of the property. And number 3 is the listing price. Oh, and E, at the very top of the page, you'll check if the property is or is not a part of an HOA. Number 3 is the listing price. In the first blank, you'll put the list price that your client has decided on. The seller must also pay all the closing costs associated with residential sales in Texas. Seller closing costs typically range from 6 to 10% of the property's contracted purchase price, and the buyer closing costs generally range from 2 to 6% based on the size of the mortgage. Number 4 is the term. So here you'll write the listing start date followed by the end date. Most agents will let a contract run for a minimum of 6 to 12 months so that you have enough time to market and show the property to attract the right buyers. This clause also explains that if the seller were to be contractually bound to another broker to sell the property before the start of this contract would be considered void. Number 5 is broker compensation. So you'll check which option applies. A, the broker's fee with compensation for the other broker. So if the seller is going to pay a cooperating broker fee, the dollar amount or percentage will go in 1A. So that would be the total compensation amount agreed upon with the seller that will be distributed to both the seller and buyer agents. There is no set rate or commission. Everything is negotiable. And then 1B, you'll check the box if your client will pay a flat fee, and this would be most common in land sales. Number 2, here you'll input the compensation amount, which will be offered to the other broker who brings a buyer to the sale, if the seller is indeed offering compensation to the buyer's broker. B describes a sub-agent that would arise when a cooperating sales associate from another brokerage shows the property to a buyer. The sub-agent works with the buyer to show the property, but owes fiduciary duties to the listing broker and seller. B, brokers fees without compensation for the other broker. So you'll check either A or B. If B is checked, you'll put the amount to be paid to the broker only, if it's a percentage of the sales price, or B, if it's a flat fee. C is earned. So the broker's commission is earned when any of the following things happen during the listing. Number one, the seller sells or gives the property to someone at any price or terms. Number two, the broker individually or with a cooperating broker finds a ready and willing buyer who can buy the property at the terms acceptable to the seller. Number three, if the seller breaches the contract. D is payable. Once the broker earns their commission, it is payable during or after the ending of the contractual term. If, number one, the property has been closed, sold, or exchanged. Number two, the seller refuses to sell the property after the broker's commission has been earned. Number three, the seller breaches the contract. Number four, any other time which is described in this contract. The broker's compensation will not be paid if the property doesn't sell as a result of one, the seller's failure to deliver a deed or title policy to the buyer. Number two, loss of ownership due to foreclosure. Number three, the seller's failure to restore the property as a result of casualty loss. E, other compensations. So if there is a breach of contract that results in the seller collecting earnest money, the sales price, or a settlement, they must pay the brokerage. The stipulations on this payment are listed here. If the broker refers a service provider to the seller, they are allowed to receive a fee from the service provider for the referral. If there are any photography fees, administrative fees, etc., that would go in number three. And F is the protection period. So fill in the blank. Usually it's 90 days. So if the listing agreement expires or is canceled at any point, 90 days after that, if a buyer is found, the broker will still get a commission. Within 10 days after the listing ends, the broker needs to send the seller in writing a list of potential buyers they procured during the listing period. If the home then sells to one of these buyers, the seller must pay the broker their commission. Protection period paragraph will not apply if they choose to sell this property within the protection period, but the property is listed with a different brokerage who is also due a commission. G is the county. So here you'll put the county where the brokerage is located. H is the escrow authorization, which states that the seller is giving the title company the authority to take the funds from the seller's proceeds and distribute commission. Number 6 is the listing services. This contract must be put into MLS within 1 business day of activating this contract, and the contract being publicly marketed. So that would include things like flyers, yard signs, digital marketing on websites, emails, etc. Filing. The seller asks the broker to either check 1 or 2. The broker will file this into MLS according to check A or B, file the listing within 5 business days of the start, or the seller instructs the broker not to file this listing with MLS until blank days of their choosing after the start date. And you're going to need to write the reason. Usually, if the house needs to be staged or have photos or repairs, that would take longer than 5 days. Any information provided as a submission to MLS will become the property of that MLS, and members must update information about their listing per the MLS rules. The broker will not file this listing with any MLS or listing services, so that's the second option. If the seller checks this box, they must understand that the property won't be publicly marketed at all and will not be in the MLS database, which means the other agents won't be aware the property is listed for sale. And an important note is that if the property is publicly marketed by anyone, the broker has to file the listing agreement with the MLS within 1 business day of that happening. So what that means is that if the second option is checked, in which the seller does not want their listing on MLS, if any other agent, accidentally, makes it publicly makes it public knowledge that this listing is for sale, the listing does have to go into MLS. Listing content. So if this listing is going into MLS in accordance with paragraph 6A, both the seller and broker agree on these definitions. So listing content means all marketing material pertaining to the property. Seller listing content will be everything provided by the seller to the broker, and broker listing content will be listing content that is procured by the brokerage and their associates. Number 2, the seller is granting the broker the exclusive right to list the property and use the content in any way necessary. All broker listing content is owned by the broker, and the seller doesn't have any rights to it. The seller agrees that both the seller listing content and the broker listing content will be filed with MLS and may be publicly displayed and reproduced. Access to the property. Authorizing access means that the seller is allowing the broker to allow other brokers to enter and view the property, share security codes, and lockbox access. And the broker is allowed to access the property at reasonable times, authorize other brokers, their associates, inspectors, appraisers, and contractors to access the property at reasonable times, and duplicate property keys for efficient property showing. If the broker wants to use a showing company to schedule appointments, that should be listed here. Showing time is a popular example. And key box. So this clause describes a lockbox and how one operates. It explains to the seller that by using a lockbox, they are increasing the number of showings that can take place on a given day. This will increase the chance that it sells quickly. The use of a lockbox does come with risks, and the seller should be made aware of that. The seller must check whether they authorize the use of a lockbox or not. If the property is tenant occupied during the time of this listing, the seller must provide the broker with a written statement from the tenant stating that they authorize the broker to use the lockbox. Liability and indemnification. The seller must assume all risks associated with the use of a lockbox and indemnify the broker and any other broker who've used the property of any liability, loss, damage, or injury. Number 9, intermediary. So intermediary status would happen if the same brokerage ended up representing both the buyer and the seller. If the interested buyer comes from either the listing agent or another agent within the brokerage, the seller authorizes the broker to act as an intermediary. These are the 3 situations in which an intermediary status might take place. If the buyer is represented by a real estate agent within the same brokerage, if the real estate agent who found the buyer is the same who represents the seller, or if the broker doesn't want to take any of the actions listed above, they don't want to appoint another associate to work with the buyer, then the broker will let the seller know that they will act only as an intermediary representative who can facilitate the transaction and cannot give any advice or opinions to either party. So Texas is not a dual agency state, and instead they have this intermediary status. And so that would be A, and then B is going to be no intermediary status. So you're going to check this box if the seller doesn't want to opt into A and chooses instead to not allow the broker to show the property to any potential buyer they represent. If 9A is checked, the broker and all associates must not disclose to prospective buyers that the seller will accept a price less than the asking price unless given written approval from the seller. They will not disclose to the seller that the prospective buyer will pay a price greater than the price listed on their offer unless given written approval. They will not disclose any confidential information to their respective parties unless required by law or instructed in writing. They will not treat either party dishonestly, and they will not violate the Real Estate License Act. And then the above notices will survive this contract. Number 11 is broker's authority. Within reason, the broker will make all efforts to market this listing, find a buyer, and negotiate the sale of the property. So if 6A1 is checked, the broker can place this listing on the internet with no limitations unless check one. So check one if any of these apply. The seller doesn't want the listing displayed on the internet, or the seller doesn't want the property address displayed on the internet. The seller must acknowledge their understanding that if 11B1 is checked, consumers who search for listings online won't see any information about their listing. And then in C, the seller must check which type of financing they will accept from a buyer. D, following MLS rules, this clause states that the broker can advertise the property on the internet with photos, videos, and ads, place a for sale sign on the property, give CMAs about other properties to potential buyers, give out information regarding the property to other brokers inside and outside of the brokerage and to interested buyers or their representatives. Receive information from a note holder regarding any liens, accept and deposit earnest money to a trust, disclose the sales price and terms of the sale to other brokers, appraisers, and real estate professionals, disclose whether the seller is looking at more than one offer if asked, advertise that the broker sold the property after the sale closes, place information about the property on the internet based on transaction or internet-based transaction software. So things like CRMs and Dotloop, Skyslope, etc. And then F, you'll check the box that applies. So either the seller does or does not authorize the broker to share with other buyers and brokers that the seller will consider contributing a certain amount of money toward the buyer's expenses, like buyer broker fees. The seller is not obligated to do so. And then 12 is the seller's representations. So unless otherwise stipulated in paragraph 15, the seller asserts that they have fee simple title to the property, the improvements, the fixtures, and the legal capacity to convey the property. The seller is not currently contractually bound by another listing agreement. Any pool, spa, or other enclosures comply with all laws. No other person has the right to purchase, lease, or acquire the property. The seller is up to date on all loan payments and other financial obligations related to the property. The seller is not aware of any liens or encumbrances. The property is not subject to the jurisdiction of any court. All information relating to the property that the seller sends to the broker is true and correct. And in the blank at letter I, you'll write the name of the company that will be providing the seller relocation service, if at all. And the seller listing content and use granted to the broker does not violate or infringe on anyone's rights. The seller knows the property is located in a public improvement district, municipality utility district, or other statutorily created districts providing a public service, and you'll list those here. And then seller's additional promises. The seller agrees to cooperate with the broker to facilitate all aspects of the sale, including showings and marketing, not rent or lease the property during this listing period without the broker's written approval, not negotiate with a prospective buyer who might contact the seller directly. The seller will refer all buyers to the broker. The seller will not enter into a listing agreement with another brokerage during this listing without the broker's written approval. And if 6A2 is checked, the seller must inform the broker immediately upon learning that the property is being publicly marketed in any way. Maintain any pool and enclosures in compliance with all laws. Provide the broker with copies of any leases about the property and advise the broker if tenants are moving in or out. Complete any disclosures or notices required by law or contract to sell this property. Amend any applicable notices or disclosures of material changes that occur during this listing. And number 14, limitations of liability. So this clause releases the broker of liability due to anything other than their negligence. If the property is or becomes vacant during this listing, the seller needs to notify the seller's casualty insurance company and ask for a vacancy clause to cover the property. The broker is not responsible for the property's security. The broker is not liable for personal injury or loss resulting from an act or omission not caused by the broker. Other brokers, associates, and inspectors, appraisers, and contractors who are authorized to access the property, and other brokers to their associates who have information on the property placed on their website. And any acts by a third party. The broker is not responsible for freezing water pipes, any dangerous conditions on the property's non-compliance with any laws or ordinances, and for the seller in any way. The seller agrees to protect, defend, indemnify, and hold the broker harmless from damage, costs, attorney's fees, and expenses, which are caused by seller negligence or arise from the seller's failure to disclose material information about the property, or caused by the seller giving incorrect information to anyone. Number 15 are special stipulations. So this section was designed to allow sellers to make factual statements and attend to business details that might arise in a sale and is not covered by the contract or a TREC addendum. TREC rules prohibit licensees from adding factual statements or business details for which a contract addendum, lease, or other form has been promulgated by TREC for mandatory use. If you use this field, please do so with great caution. The primary danger of placing a statement in the special stipulations is risk of violating the Realtor Code of Ethics, which prohibits agents from engaging in any unauthorized practice of law. So you should always use specific contractual language. You can check with your broker on this, and you should always advise your client to consult with an attorney. There is also the Texas Realtors Legal Hotline, and I have the phone number for that right here. And they can answer general questions, nothing specific about any particular sale, but they can give you some general broad advice. So 16 default. If the seller doesn't cooperate with the broker to allow showings, marketing, or the sale of the property to happen, the seller will be in default of the contract and will be liable to pay the broker commission outlined in paragraph 5, along with any other compensation. The broker can also terminate this listing and make any other lawful response. Mediation. So both parties will agree to negotiate in good faith, and if a dispute arises, they will go to mediation. If a dispute goes through a legal proceeding, the winning party will be entitled to recover all costs associated with the legal proceeding and any reasonable attorney's fees. Please check all of the addenda here that apply and should be included in the listing agreement. If you need to add something, you can write it in option P. Number 20, agreement of parties. So the listing constitutes the entire agreement and can only be changed with written agreement by both. Neither party can assign this listing to anybody without the written consent from the other party. The seller's obligations to pay the broker's compensation is binding to the seller's heirs and successors. The sellers in the agreement are individually and jointly liable for the performance of all terms. Texas law governs the interpretation, validity, and enforcement of the listing. If a court finds any clause in this listing to be invalid or unenforceable, the result of the listing will remain intact and uninfected. Any notices between the parties must be made in writing and are effective when sent to the other party. And additional notices. The broker's service must comply with fair housing laws and the code of ethics. The broker advises the seller to contact any mortgage lender or other lien holder to obtain information regarding payoff amounts for current mortgages or liens. The broker advises the seller to review all information submitted by the broker to MLS or other listing services. The broker advises the seller to remove jewelry and valuables, including weapons and prescription drugs, from the property. The broker advises the seller to consult with an attorney before using surveillance devices. And if compliance with statutes or ordinances is not adhered to, the transaction might be delayed and could result in fines for the seller. If the property was built before 1978, federal law requires the seller to provide the buyer with federally approved pamphlet, disclose the presence of lead-based paint on the property, deliver records relating to the property hazards, and provide the buyer up to 10 days to review the documents and have a property inspector inspect the property. If the seller is foreign, the buyer might be required to withhold a certain amount from the sales proceeds as applicable to law. This applies if the foreign seller is a non-resident alien, a foreign corporation that has not made an election under 897I of the IRC as to be treated like a domestic corporation, or a foreign partnership trust or estate. The seller must check whether they are or are not a foreign person. The broker advises the seller to not transmit personal information, including financial information, via unsecured email or other electronic communications to avoid wire fraud. And then we have the signing section of the contract. The broker and the sellers need to sign and print. And that is all we have today. So I will stop recording and I will open it up for any questions.